This video features Commissioner Richard G. Vogl, who will share his suggestions for the first hearing in your case. Commissioner Vogl served over 25 years as a judicial officer for the Orange County Superior Court until retirement in April of 2013. Prior to his judicial career, he was a family law lawyer for 18 years. He presently serves in the capacity of a privately compensated judicial officer in Orange County and surrounding counties. In Part 1 of this presentation, Commissioner Vogl will review the basic rules for automatic temporary restraining orders. In Part 2 he will provide planning ideas to counter potential problems. If you need additional time for note-taking, please move your mouse to the bottom of this screen. Two parallel vertical lines should appear. Clicking on these vertical lines will pause your presentation until you click on the right-facing triangle, if you have a print screen button on your keyboard at upper right. You may take a picture of your screen and paste into an email or word processing document. You can also take a photo of an order in this program with your iPhone. And now, here is Commissioner Vogl's avatar delivering the Commissioner's observations and recommendations.
It is so easy to get caught up with the immediate needs of a client after the interview that sometimes one forgets to go back to basics. Good practice would indicate that you should have a checklist of items to ask for. Always want to at least consider each item on the list when making your request for orders in the first court hearing. Remember that although some provisions of the law are automatic when parties have no attorneys and seek no advice, they are blind to their duties. Because of that, it is wise to sometimes ask for orders which seem repetitive, but actually are putting the other party on notice of important tactics. Let's go over what might be on your checklist. 1. That the other party acknowledge that pursuant to the automatic temporary restraining orders of Family Code Section 2040, they are restrained from transferring, encumbering, hypothecating, concealing, or in any way disposing of any property, real or personal, whether community, quasi-community, or separate, without the written consent of the other party or an order of the court, except in the usual course of business or for the necessities of life. That each party acknowledge that pursuant to the automatic temporary restraining orders, they are to notify the other party of any proposed extraordinary expenditures at least 5 business days before incurring those expenditures, and to account to the court for all extraordinary expenditures made after service of the summons on that party. 3. That each party acknowledge that pursuant to the automatic temporary restraining orders, they are restrained from cashing, borrowing against, canceling, transferring, disposing of, or changing the beneficiaries of any insurance or other coverage, including life, health, automobile, and disability, held for the benefit of the parties and their child or children for whom support may be ordered. That each party acknowledge that pursuant to the automatic temporary restraining orders, they are restrained from creating a non-probate transfer or modifying a non-probate transfer in a manner that affects the disposition of property subject to the transfer, without the written consent of the other party or an order of the court. 5. That each party acknowledge that they are restrained from removing any minor child or children of the parties, if any, from the state without the prior written consent of the other party or an order of the court.
In the second and last part of this presentation, Commissioner Vogl will discuss 8 possibilities that may need advanced planning.
Let's plan for the event that one party may want to terminate a joint tenancy and prepare a request for this order that should either party terminate any joint tenancy, that advance notice be given of at least 10 days, and that the court shall retain jurisdiction to impose sanctions if no notice is given. Civil Code 683.2. Let's plan for the event that one party has been reducing their income until after the hearing and then will once again seek additional income, and ask for this order, that should the gross monthly income of the other party become modified in a sum of 10%, that party will give written notice of such change. Let's deal with the issue of the needs of the children over and above the money due each month as child support and ask for this order, that in addition to child support, each parent shall be responsible and be liable to pay such additional sums as the children may require for dental, orthodontic, mental health, counseling, sports equipment, athletic clothing, optical, prescription, prescribed massage and physiotherapy, psychological care, and other associated costs such as insurance deductible sums as additional child pursuant to Family Code Section 4062, and that the obligation of the parties shall be in the same proportion as either their gross or net incomes. Let's deal with that recurring issue of who claims the child as a tax deduction and ask for these orders. Number 1, that the party who has the child in their home for 183 overnights in the year shall be entitled to claim the child as a tax deduction. Number 2, if the party paying child support falls in arrears in a sum equal to 2 months, then that party's right to claim the child as an exemption for the year shall terminate. Let's deal with the issue of a father not wanting to pay child support as ordered. Number 1, that the child support monthly sum shall not be reduced for any period during the summer when the child may be with the non-custodial party for summer vacation. Number 2, that the party paying child support shall be specifically ordered that he/she is not authorized to make any deduction from said support for payments made by the payer for the benefit of the support recipient or supported child. Number 3, that should the party paying child support be in arrears in a sum equal to 2 months, then the party receiving child support may give notice to request a hearing under Family Code 4560 for the posting of security in a sum equal to 1 year's child support. Let's be specific as to the requirements for insurance and ask for these orders. Number 1. Each party shall maintain the children beneficiaries under all life insurance policies as they may have available to them through their place of work, but only so long as the children are under the age of 19. Number 2. That the non-custodial parent maintains medical insurance for the custodial parent and the children as available through their place of work. Let us foresee the difficulty of the parties continuing to use joint credit cards and ask for these orders. Number 1, that each party shall terminate using any joint credit cards but shall establish separate credit accounts. Number 2. That each party terminate the use of any joint bank account except for payment of community expenses, and that written notice shall be given to the other party upon any such payment. Let us foresee difficulty with gathering evidence, and ask for these orders. Number 1. That each party preserve all electronically stored information of a personal or business nature. Number 2. That each party shall within 30 days from the date of the court hearing provide to the other party any and all information in regards to any pension, retirement, or other benefits which may be due them, which shall include the name of the obligor, address, telephone number, and any account number. Number 3, that each party acknowledge that pursuant to case law, the fiduciary duties of each spouse to the other, mandate that should they become eligible for a post-separation investment, they must share that investment opportunity with the other spouse. Number 4. Should any monthly installment on attorney's fees ordered be unpaid by 5 days from the date said sum is due, that the entire sum shall then become entirely due and payable and bear interest at the legal rate thereafter. But this list is only a starting point. I would be interested in hearing your ideas.